Hello, welcome back to my channel. Yes, we've got some more KJ stuff because since it was all revealed that there was this default judgment and everything, hello Cal, we've had Twitter meltdown. Very interesting. We're being schooled on law with the, by KJ. But look, just fixing up my microphone. I didn't realize my microphone was unplugged. Hopefully you can hear me better now. Hopefully you can hear me better now. Let me know if you can or you can't. That would be good. What I'm finding really interesting is that I tend to go by what the courts are saying. Now, we'll have a look at their latest Twitter, but we've got today, as I said, I only go by what's filed in the court. So let's have a look. There's two documents that are in there today. So we went through yesterday. Surprised to catch you at 6. I know it's 6 a.m. I know it's is it 9 o'clock here? I should be studying. There is filed is notice of remote hearing with instructions and notice of motion and motion. So we've still got, there's a motion hearing on the 21st of the 11th. Now that motion hearing is for 7M's motion for suppressed discovery and for delayed discovery. So that's the motion that they filed. The default hearing is for the default motion that was filed, that we went through yesterday. But we've got so much protesting going on at the moment that it's really quite, well, I don't know. If I was her lawyer, I'd be telling her to please be quiet. Because I just don't think that she's helping the cause. I mean, there's a reason why you pay lawyers to represent you and generally to do all your talking for you. So here we go. She says, for your information, for those that are unclear about Minnesota court rules, responses to motions are not due until 14 days before a motion hearing. Our hearing is not until November 21. No deadlines were missed. See Rule 115 motion practice. And so that's what she's using. Then she says, when the judge denied our motion to dismiss, the judge did not set a date for the answer to the complaint. We had already responded to the lawsuit and we were never non-respondent. The answer is now filed in court. 7M Robertson and others failed to serve us with discovery demands on the 8th of the 5th. They haven't responded to our discovery request served on them on the 5th of the 8th. The due date for discovery was the 5th of the 9th. As a result, we're filing a motion to compel and seeking attorney fees. Well, you can't do that, Katie Joy, because they filed a motion regarding delayed discovery, which is being heard on the 21st of November. But that's okay. So that's what's happened there. So that's what's been happening. So let's have a look at these documents. So we've got an amended notice of motion. So it says, please take note, the plaintiff 7M's, Robert Shin, Miranda Derrick, James, will bring forward the hearing. It's November 21 at 1:30 via Zoom with the ID and passcode. Plaintiffs will hereby do move the court on the above mentioned state time following the order for default pursuant to rules 12.01 and 5501 of the Minnesota Court of Procedure, and the motion is brought pursuant to Okay, so they're still following. In fact, let's just have a look at what the Minnesota. So she's quoted 115. She's quoted 115. Let's look at the Minnesota court rules. Minnesota. Hello. Are you enjoying Hello Without a Lawyer? How are you? So we're looking at what rule are we looking at? 12.01. So let's see what rule 12.01 because remember she wanted to school us on Minnesota rules. So here is the rule that that 7M is relying on, the civil. Right. All right. So Minnesota civil procedure rules, and I'm using, all right. Default shall serve an answer within 20 days after service of the summons upon the defendant, unless the court directs otherwise, pursuant to Rule 4.043. A party served with a pleading stating a cross-claim against that party shall serve an answer within 20 days. The plaintiff shall serve within 20 days if a reply is ordered by the court within 20 days after service of it. If the court denies the motion, so this is what they're, so remember, she's talking about she's used the general rules, but see, there is in it talks about, so remember, she served a motion in here. If the court denies the motion or postpones its disposition until the trial on the merits, the responsive pleading shall be served within 10 days after service of the notice of the court's action. If the court grants a motion for a more definite statement, the responsive pleading shall be served within 10 days. So, because they had this other motion that she filed, they're using this rule because remember, she had a motion, she filed a motion to dismiss. So they're using this one. This is 12.01. Let's just screenshot that. All right. All right. So that's 12.01. So they're relying on that rule. And the other rule that they're using is Minnesota Civil Procedure 55.01. Okay, 5501. Judgment. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend within the time allowed, therefore by rules or by statute, and the fact is made to appear by affidavit, judgment by default shall be entered against the plaintiff. So here it is. Okay. So they are the two rules that 7M are relying on. Now, my understanding of the rule that she quoted, 12 point, is the initial pleadings. That's my understanding. But as I said, I'm not a US. I'm just interpreting these as I. So then we've got, and this I think speaks volumes because the court has said, you are notified of a motion default hearing at 1:30 p.m. So it's a motion for 7M discovery to be sealed or protected, and their reasons for delay, because remember they wrote to the court and the court said, hey, we've got it, but you've got to file a motion. And so they filed the motion and it was scheduled for the 21st of the 11th. The other thing is, now there's a bit of discussion about whether it was in fact court initiated the default judgment hearing and then 7M, or whether 7M's done it. And I can't remember, but I do remember thinking it odd that there was a default hearing. I think it's the court that's done it. So that's okay. So we now just have to wait for her files to come in. But as I said, there's nothing there. Now she's saying that their reply and answer has been done. I'm going to be very interested to see. I mean, this will come down to whether the judge thinks that her or the general rules apply, or whether 1201 applies. Because if 1201 applies, Civil Procedure Rule 1201, then she's out of time. But if the court takes, so let's have a look at, she's quoted, Katie Joyce quoted 115. Now, Minnesota Civil Procedure 115. Isn't this great, looking up laws and stuff like that? I've become very proficient at this. I've become very, very, very clever at this. Oh dear. She may be out of luck this. Well, here's the thing. I just don't know where or how she's got to. It's funny. I can't pull up the rule. It doesn't come up. She may be out of luck. As I said, I think. Let's have a look. 115. No, 155, wasn't it? She might be out of luck. She may be really out of luck this time. You're right. Particularly if the court has actually initiated it, because sometimes if something's not filed, the court will automatically set through. Okay, so this is what she's using here. The rule shall govern also except those in family courts, and all commitment proceeding and the motions I don't emotions, okay, time. So she's using this. Oh, ha! No motion shall be heard until the moving party pays any required motion. Notice of motion. The party responding to motion shall pay any required motion. Serve the following documents on all opposing counsel. Yeah. The moving party may submit a reply memorandum limited to new legal factual 7 days. Where's she getting this from? This is 115. Why can't I get what she's got here? Party before the hearing. Part B. But that's for here. That's for a dispositive motion. Dispositive motions are motions which seek to dispose all of part of the claims or parties except motions for default judgment. They include motions to dismiss party claims. She's using the wrong. It's not a dispositive motion. It says accept motions for default judgment. So she's come down here. She's wrong. It's a non-dispositive motion, but it says at least 14 days. Any memorandum tends to submit. But see, then there has to be a if the moving documents are not properly served and filed, the hearing may be cancelled by the court. If response documents are not properly served and filed the court may deem the motion unopposed and may grant relief without a hearing. So, yeah, look, it's bizarre, but what she's quoted, she hasn't stated which one she's quoted. If you actually look at what she's put up here, see Rule 115 motion practice, you just can't pick out a thing and go, hey, this is it. Because, as I said, if you look at the motion, if you look at 115 motion practice, it says accept motions to dismiss for default judgment. And in fact, if you look at non-dispositive motions, all other motions except, but include discovery, third-party practice, temporary relief, injunction. Technically, if we wanted to get technical, about, because there is a motion hearing regarding discovery, right? Technically, 7M doesn't have to respond until 14 days before the hearing either, technically, if we really want to. Additional requirement for summary judgment motions. A statement by the moving party of the issues involved. A statement identifying all the documents, all the pleadings which comprise on the record on which the motion opposing party shall identify in their responding memorandum of law any additional documents which they rely. So remember, for default judgment, they're saying there's nothing on the court file, which is true. A recital by the moving party material of facts as to which there is no genuine dispute. There's the parties' arguments and authorities, which they've done. So they've done all of that. Now, because this is what my interpretation is, as I said, I'm not a Minnesota lawyer, because it's a default judgment, which is a different motion, right? It has a completely different set of time frame. And even if the other issue is, great to see me. Well, yeah, I'm doing all right. The other interesting thing is she's referring to this time, right? The motion hearing. The motion hearing was for 7M's discovery. It had nothing to do with the actual hearing. She's never filed a defense. She never filed a defense. If we look at the time limits, okay, for that, she's well out of time. So I don't really know what she's talking about because she's never filed a defense. If she filed a defense and they filed summary judgment, I'd say yes. But the motion hearing is for 7M application. Where are we? 7M's application for sealed records and extension of time for discovery. Let's go back. Let's go back a bit, hey? This was what it was for. It was not for anything else. So let's go down here. Notice of motion on the 30th. We had one here. Remember, they had the filing of the. Was that the one? My computer does some really weird things at the moment, so let's have a look. So KJ, in my opinion, KJ is you talking about. Yes, here we go. KJ is talking about the motion hearing is about, and she's already said that they've addressed it. They've already opposed it. So they've opposed all of this. So let's have a look. We're going to pull this up here. This was, that's not it. Where are we? Oh, I can't remember. I've got all these files. I've got all these files sitting here open. If you remember, the hearing was for this one. Not that one. It has to be this one. They've all got all similar titles. This was what it was for. Okay. This is what it was for. Well, and that's my whole point, plan to create. How can she ask for compulsion for discovery when she hasn't actually filed anything? So this was filed on the 26th of August. Notion of motion and motions for temporary injunctive relief, protective discovery order, and amended scheduling order. This is the motion that is going to be heard on the 25th of November. It's got nothing else. The 21st of November. This still doesn't take away from the fact that she hasn't actually replied to it. So they wanted a temporary injunction. a protective discovery and amended scheduling order. That is what is being heard on the 21st of November, not what Katie Joy is talking about. Now she's saying, oh, we're going to file a motion to compel. The judge hasn't actually ordered on any of that yet. How can you compel something that hasn't been ruled on? Somebody's in a little bit of a dream world, in my opinion. And I think Graham Cracker's got to come and get his girl, because she's, in my opinion, not helping things. Not helping things. Let's wait and see, says Cal. Be very interesting. Very interesting. But there is, like she said, I don't know how long it takes for them to be uploaded or filed. But as I said, this is the current court filings. I'd love to sit here and see her filings appear. So that one we've looked at. We've looked at notice of motion and motion, remote hearing. We've looked at the proposed order. We've looked at all the affidavit of attorney. We've looked at that. We've looked at that. We've actually looked at everything. We've got the order denying motion, notice of judicial correspondence. Remember, on the 8th of the 8th, this is where 7M had said, we've tried to contact the court, and then the court, they've written to the court, and the court says you've got to file a motion, so they filed a motion. And the date, if you actually hear, look at this, motion hearing, the 21st of the 11th at 1:30. The default hearing has occurred because she's never responded. Now, I don't know. In Australia, if you're out of time, 7M is the firm that's suing her, 7M Films. Robert Shin, Miranda Derrick, James Derrick. Because she called them human... she talked about human trafficking and yeah, she's done her usual. So, but that's the thing is, here's the issue: if the judge grants the default judgment, it's all over Red Rover for her. So she can appeal, but I don't know how she can appeal if she never filed a defense. You know, you can't appeal something if you don't file a defense. We remember, and we saw that with Google and Barilaro. Google just in the end, well, I mean, Google had the money, but they just went, this is, you know, we're not going to defend this, we'll just pay up. You know, and everyone goes about their business. But Katie Joy doesn't have that. And if they get their injunction, which they're asking for, where she's not allowed to talk about them, and anybody associated with her isn't allowed to talk about her, that's going to be a tough pill to swallow. So it is my opinion, the best thing that she can do is to try and reach a settlement with them. And I don't know why people are, you know, lapping up her every word. But I mean, you just have to look at the documents for themselves. You cannot see that there's a reply. They've replied that we'll ruin the next. Well, and then here's the thing: Plan to Create. Will Netflix then sue her for breach of contract, for example, if she's got a contract? I don't think 7M will settle either. And I can't help but wonder whether part of the Chrisley settlement was because he figured that after 7M had got hold of her, that there was going to be nothing left. That they thought that 7M might have had the best case, and if they're going to get that, if he was going to sue her for an amount, that there's going to be no money. There's that running through my head, because You can't, like the Queen paying 13 mil to make the issue go away about, yes, that's correct, Cal. If you got money, you can make issues go away. But I mean, and the whole thing with the Shanks Barilaro thing is that Shanks actually is still able to talk about him in his previous role as Deputy Premier of New South Wales. Katie Joy can't talk about anything about the Chrisleys or the family or anything in any aspect. What did I miss? I had to work for 10 minutes. We've just gone through and stated that the hearing that's been heard, the motion that's been heard on the 21st of November, is the injunction for her not to be able to talk publicly about it, the sealed orders, and an amended discovery schedule. That's what's happening on the 21st of November, as well as the default judgment. What KJ's saying, she's got 14 days before the motion. Her reply is technically well and truly out of time. That's the factor. Now, in Australia, they don't necessarily accept. You actually have to go to the court and ask permission to submit a document out of time with a legitimate reason. I don't know how it works over there. The court may not accept it. Or they may add on that they go, well, there's already a hearing on the 21st. We'll add this on here as well. But so she could turn up on the 21st, have the judge say, your defense is out of time, we're throwing it out. If the default judgment's granted, everything else becomes, to use the word that KJ likes, moot. It becomes moot. Nothing, it won't matter. Discovery orders won't be needed. And in fact, interestingly, where she talks about it being moot, right? This is what's hilarious. In law, it means a mock judicial proceeding set up to examine a hypothetical case as an academic exercise. So where she talks about the case being moot, a mock judicial proceeding, yeah. But I think she's using it in here, subject to debate, dispute, or uncertainty. But in law, when you talk about moot, we use the word moot all the time, moot. A mock judicial proceeding. So, because we do it all the time, we have moot courts and moot hearings, and but so all of that. If the judge grants default judgment, everything else becomes irrelevant. So, as I said, my understanding is, as how it works in Australia. Remember, I can only talk about Australia, and I'm a law student, so this is not legal advice. This is that you have to actually apply to the court to submit documents out of time. I hate that term. I know it's and again, it can be taken out of context a lot too. And so whether she has to apply to the court for being out of time, I just saw your comment, Cal, that you're over it. Yeah, look, I don't talk about her a lot these days unless I'm really just covering the court stuff now. I can't be bothered with everything else. But that normally you'd have to ask permission to file out of time if the court grants it. And the other side gets to oppose it too. I mean, she just can't expect to file the documents and have everybody pretend and let everything in. It doesn't work like that. They 7M have to respond, and they're going to rely on 12.01, which states, which we went through. Now, I thought the rules that she quoted, Katie Joy quoted, were for the initial proceedings, but as I said, my interpretation could be wrong. But general documents, in most of the time, it's 14 to 21 days is generally the rule for everything. So, yeah. I know Friendly Geordie's just got engaged, in case anyone was interested. Friendly Geordie's got engaged. That was pretty good. So that's, pretty good stuff. I haven't looked at that. The other thing I want to talk about, at a point which I'm looking at is should your religious convictions so there was a CEO that had to resign because he was associated to a conservative Christian church. Is that right? And I will point out, and can you have certain beliefs and still be in a job? That's, I guess, because you can't ask somebody about their religious affiliation, religious beliefs in a job interview, but as long as they're not exerting those beliefs over the job, is that an issue? So I want to have a big discussion about that. So if you'd like to let me know if you'd like to be part of that discussion. I'd like to try and get people from all different sides, all different faiths, to have a discussion about that, a respectful discussion about that. I'd be very, very interested in that. Anyway, that's all I really wanted to say was and talk about was the fact there is still nothing in the courts from Katie Joy, that all the information for the remote hearing, Essendon just sacked him. Religion has nothing to do with footy. That's correct, but does that mean that he couldn't do his job though, because he had a religious belief? What if he could have been just what they needed? Because everyone said that Essendon lacked integrity and morals. Well, what if he brought that to the table? I don't know. I'm just throwing things out there. But anyway, Cal, we'll have to set a date and we can have a discussion about it, because we'll do it as a live, and we'll have a bit of a chat about it. But so particularly, and what's really interesting is that somebody with a different religious affiliations stood down from around the football because of their religious beliefs. So they weren't Christian, and there was a little bit of, but they weren't sacked or anything. So I'm just saying, if you want inclusive, anyway, just interesting. But anyway, it's just a very interesting discussion and perspective and everything. And I think a sports commentator, Darren Parkin, sort of threw that into the wind about the AFLW, and just threw it out there. So he says the hypocrisy over whose religious beliefs are a problem and whose aren't is quite amusing, especially when the religious beliefs are basically the same. So, anyway, it's just very interesting. Both the Islamic faith and Christianity is based on the Abrahamic, But anyway, that's a discussion for another night, another day. But anyway, thank you for joining me. Make sure you hit like and subscribe. Look, ring the bell, because that way you can that way you can keep up with everything that's going on, and I will catch you again next time. If you want to be part of my little discussion and debate, let me know, and we'll have a bit of a discussion. Okay, bye for now.